Hi friends from around the world. Do you know LEGO? Yes, you know LEGO. I'm sure you do. I have played when I was a child with LEGO bricks, so one-on-one as a modular system, a toy which you can assembly and build a castle if you want. Now that is LEGO. Here on the screen there is one LEGO toy, piece. Now I would like to ask you a question. What would you do? You are a practitioner in your home jurisdiction if a client comes across and tells you, well, this is what I produce. How would you assess, or how would you suggest that I protect this piece of work, so to say? Would you go for, I don't know, would you go for copyright? Would you go for designs? Would you go for trademark? Would you go for unregistered design? What is your assessment on that? Well, you know my preference to go deeper and to know the business strategy, and then on the business strategy to build upon a IP strategy. But it would be so possible to make a trademark or a design registration. Copyright is not necessary for registry. That would be a possibility, right? So I want to, you know LEGO, but you probably don't know the LEGO saga, judicial saga in Europe. This has a long way to go, and I will start up here, and I will focus today on the design part of that saga. There exists also a trademark leg, but which was before. I will refer to it a bit afterwards. Now, what are the facts here? We have LEGO. This is a company in Denmark which applies for a design, a European Union design, which is here on the screen, and for goods in art in classification of Locarno number 21, classification 21, toys for modular toys or something, bricks or whatever it is. So that was in 2010. In 2015, and that was registered as asked for. So in 2015 there was a invalidation claim against this registration on the basis of Article 8.1 of the Community Trademark Regulation. What does Article 8.1 says? Well, it is, well, you know that probably from the trademark Article 7.1e. It is if the shape of the product is only the result of the technical function of what is the purpose of the good itself, then it is not possible to register. That is a normal thing. I would say it is common sense. Why would you give originality to a product which is only possible in order to fulfill its function? You would practically stop innovation by hindering other people to make the same thing just in order to fulfill a function in order to do so. So that is a kind of common sense. Article 8.1 Community Design Regulation. I will come to a bit later to it. So Article 8.1 was the ground on which the invalidation applicant replied on. And then it came to the cancellation division, which rejected the invalidity claim. Then LEGO appealed to the Board of Appeal, which confirmed, and then it went to the General Court. Now there's a bit of mess about 8.2, 8.3. I will go in the second part a bit into it, but let me state what the importance of the ruling of the General Court is. There are two aspects which are important here. The first aspect is Article 8.1. Article 8.1 here on the screen. So it is about the technical function, right? Now, how to, and this is now here what the, so to say, the summary of previous decisions is from the General Court. Well, it is about how to proceed when you make a assessment according to Article 8.1 of Community Design Regulation. First, you would see what is the technical function of the purpose concerned. Here it is, it is a brick which must fit with another brick and another brick so that it becomes an assemble. That is first thing. Second thing, analysis of the appearance features of that product with in the meaning of 8.4 with regard to the purpose of the technical function. So you need to go into different details of what that product is. And the boards of appeal, they went into the deep thing here, into the different elements. What is this design application? And they said the studs, the upper part of the face of the brick, which are those who comes up, and the other is put upon. So the studs on the upper face of the brick is one element. Well, probably the most important, visual important element. Now, the smaller circles on the lower face of the brick is another. Then the two rows of the bigger circles on the lower face of the brick is another. The rectangular shape at of the brick, well, is another. The thickness of the walls of the brick, well, that's also another. And the cylindrical shape of the studs. So that is what has been identified by the boards of appeal as the main features of that design registration. And it came to the conclusion, well, these are all in all, these are all conditioned due to the technical function, so that they can fit with another and being assembled to a bigger picture, so to say, to a big monument, if you want. Okay. And well, they say this is fulfilling 8.1. They don't identify anything which is not serving that purpose. So they said 8.1. Boards of appeal, right? 8.1, and this is out. So everything else, 8.2 and 8.3, have not anymore any importance because the design is already rejected. Now the assessment of the General Court was different. There was also a smooth surface on the upper face of the bricks. So that smooth surface, that was naturally LEGO who advanced that argument, and it was the General Court who picked up on this argument, and they said, well, that's another element, and which has to be assessed, and which has not been assessed by the boards of appeal, but has to be assessed in order to get the whole picture of Article 1 of the CDR. So, but it annulled the decision of the boards of appeal, so that the boards of appeal take another decision assessing also that smooth surface on the upper face of the bricks. Now, the General Court could have ended here. There is now a second part, which I will call the doctrine of Article 8. Here you have the full extent of Article 8 on the screen, 8.1, 8.2 and 8.3. Now 8.2 is about the interconnection of the interconnection part, so interoperability of a product. So it must fit to another product. It must be part of an assembly, an overall assembly, a modular system, and then there must be some features which must have fit, must have a technical function in order to put the other on. That is A2, right? And then we have A3. A3 is construed as an exception of A2 according to the literal wording. You may understand. It says literally this. Now, 8.3 says that if it is a kind of modular system, the total modular system is something which as well can be, it is an exception broadening, so to say, the protection scope of designs in order to allow innovation for a modular system. You get me? Okay, so that is the literal wording. Now, what does the General Court say to this? 8.1, we know already. All the features must have a technical purpose, so to say, technical function. 8.2 is a modular is an assembly system, and the must fit that have also a technical function, and on that purpose it must be not considered as originality, right? And 8.3, the exception. Now, the idea of the General Court is, well, if the invalidity applicant relies only on 8.1, then the design holder is not being able to prove the exception of 8.3. So it relies on what is being said by the invalidity applicant so that he can or cannot rely on 8.3 as an exception for broadening its own protection. For that reason, the exception of 8.3 is also applicable to the case of 8.1, because there is an overlap between both. 8.1 and 8.2 have a certain overlap. In that case, the overlap exists. It falls under 8.1 and 8.2. For that reason, the exception of 8.3 in favor of LEGO has also to be applied. So it remits the case back to the Boards of Appeal, because there were an assessment criteria which were not carried out in a proper way. So now with the guidelines now determined by the Boards of Appeal, it went back. So there are some issues here for the practice which you should consider, or which you can consider, and where you get some clarification from the General Court. So if you have something which is only the technical purpose, then look at what are the things which are not part of the technical purpose and which you can advance then in order to get a design protection. Must be still original and new, right? Article 5 and 6 of the design regulation. Now, there is also the possibility that it can be, the design protection is broadened, because the exception of 8.3 can be also applied to 8.1. So even if you fall under 8.1, if you're getting caught by 8.1, you can still come through the exception in 8.3, but it is up to you to prove, right? Where it is up to the invalidation applicant to prove the conditions of 8.1 or 8.2. Okay, last thing I want to mention. I said in the beginning the LEGO saga. So this case here, 2018 to 2010 to 2000, 21, so 11 years. But there was a previous one with regard to trademark. So LEGO did the same thing. For the same thing, it applied for a trademark before. and it was also rejected by the all instances. It went up to the European Court of Justice, so to the last instance in the European line of litigation, and it was also rejected there due to an equivalent provision, which is Article 8. Article 7(1)(e) of the European Union Trademark Regulation. You may look this up, and you may look up also, if you are more into this, if you have clients which are more into that kind of product, you may also want to look it up. It was here on the screen. Thanks for this one and sharing your time with me.